Day 5th of the same-sex marriage hearing concluded in the Supreme Court today. So let's see what all was argued in the court. Advocate Karuna Nundi began with a submission seeking recognition of queer marriage under secular laws, specifically provisions for OCI card holders, which involves aspects of the Citizenship Act. Nundi said that the 2011 census shows that there are at least 4.8 million queer persons and added that even this is a gross underestimate of trans people. This was in reply to the centre's earlier argument where it said that 99.9% of people fall into a gender binary, that is male or female, even if they are queer. Nundi then argued that the law permits a marriage to continue even when one spouse changes gender identity. The marriage in such a case is not automatically nullified. Chief Justice of India D.Y. Chandrachud then observed that elitism argument is just prejudice and has no bearing on how the court will decide the case. Advocate Arundhati Karju, responding to some of the questions raised by the judges earlier, spoke about how the SMA must be read with regard to succession rights. Justice Ravindra Bhatt observed that the court would have to look into how this provision will apply to same-sex couples since the court does not intend to alter personal laws. Karju argued that the same-sex couples must be treated the same way as heterosexual couples are for the issue of succession. Then Solicitor General Tushar Mehta, representing the centre, started arguing. Mehta started with saying that what has been argued so far are the questions, what is a marriage and who can marry? He added, however, that the real question is who would take a call as to what constitutes a marriage between a particular class of people. Mehta said that about 160 legislation and provisions of law other than Special Marriage Act would not reconcile if same-sex marriage is allowed. Mehta argued that the Parliament has defined transgender persons very widely to include all shades and all spectrum of what we call LGBTQ+. He, however, added that the definition does not deal with sexuality. Communities of lesbian, gay, bisexual, etc. involve the aspect of sexuality and not gender. Mehta then argued that the right to marry does not include the right to compel Parliament to change the definition of marriage. He then stated 4 limitations of interpretation on the court in recognizing same-sex marriage. First, the court can't change the character of the law. Second, the court can't substitute the legislative intent which is otherwise manifest. Third, the court can't read words with larger amplitude in place of words of smaller amplitude. And fourth, the court can't read the law in a way that there is an unintended impact on heterosexual couples. However, he did not elaborate on how it impacts heterosexual couples. Mehta then argued that the problem for the court to delve into regulating relationships is because nobody knows what the plus stands for in LGBTQAI+ spectrum. He also added that the religions have always recognized only heterosexual marriages. Mehta then cited the 2022 Dobbs versus Jackson that overruled Roe versus Wade and held that US Constitution does not confer a right to abortion. Mehta said that this judgment correctly acknowledges the limitations of judicial review. Chief Justice of India D.Y. Chandrachud then replied to his argument saying that if Mehta is relying on Dobbs to argue judicial restraint, then India has gone far beyond that, and fortunately so. Mehta then read out the parliamentary debate from 1950s when the Special Marriage Act was enacted to show that the parliament was aware of homosexuality and deliberately left that aspect out of the law. His point was that the legislative intent was never to include LGBTQ community in the marriage law. With this, the arguments concluded for today. The court will continue the hearing tomorrow.